I'd like to say hello and welcome to everyone who is joining us today for this webinar on demystifying the recent changes to national heavy vehicle law. It's certainly a popular topic. I have to say that we've had at least 20 webinar registrations this morning alone. Now, before I introduce Sue, I just have a few points about the webinar and myself. My name's Sarah O'Leary. I'm from myosh, HSEQ software. I work mainly in PR and client liaison and product development. That's about all I'll be saying for the rest of the webinar. Sue's going to be doing most of the talking. I've also got a colleague here, Jared, who writes articles for myosh. He's just bystanding in case there are any technical issues. During the webinar, all attendees will be muted, but you can ask questions via the Q&A panel that you should be able to see on your Zoom webinar software just there. Some of the questions may be answered during the session by Sue. The session is being recorded and slides will be emailed with the recording within 24 hours. I would like to thank Sue Butchell for joining us and willing to participate and sharing her expertise today. She has worked in occupational health and safety, including the transport industry and workers' comp rehabilitation for the past 18 years. Sue's also a qualified OHS professional as defined by WorkSafe and has qualifications in safety to a master's level in both health and safety and law. She's a practicing lawyer in safety and employment law and was the first safety professional in Australia to become a certified chartered generalist OHS professional member of the Safety Institute of Australia. Sue's also legal and safety expert in the management of contractor safety in respect of health and safety and under the heavy vehicle national law chain of responsibility. So without anything else from me, Sue, over to you and thank you very much.
Thanks, Sarah. Look, I will say to the participants, we have a funny little situation happening. Next door to my office is where the next series of the block is being built. So right on my boundary, I currently have a whole bunch of construction going on. I very kindly asked the guys to stop making too much noise for the next hour. So we shall see how we go. And hopefully it will be not too noisy. But if anyone has any difficulty hearing, just let me know and I'll get Scotty out there to try and rein them in. Okay, so look, thanks for that introduction, Sarah. As Sarah mentioned, my expertise, I have focused on the area of contractor management and obligations owed as between principal contractors and contractors for the last 8 years out of a 20-year health and safety career. And when the changes to the heavy vehicle national law came in last year in October, the principles which underpin how that chain of responsibility obligation is being interpreted were aligned with the law and the principles of law that I have been working on, for the last sort of 8 to 10 years. So it is an area that I find is very poorly understood across the transport industry. And I think one of the real issues under that is that the heavy vehicle industry or the transport industry seems to have operated in this kind of bit of a bubble over separately to workplace health and safety. And the general principles that underpin workplace health and safety have been different. And so a lot of people working in heavy vehicle industry, perhaps are not across some of the interpretations around the application of workplace health and safety law. And that's not a criticism or a judgment. That's just saying, you've worked under a different framework. You now are working under a framework which aligns with the harmonised and all of the state workplace health and safety laws. So I encourage you to use your workplace health and safety professionals or people who have that kind of background to assist you to understand how the heavy vehicle national law is going to be interpreted. And if you have a workplace health and safety background already, then good on you and lucky you. So I'm going to go through, let me just get this slide happening here. So just a quick overview. So the heavy vehicle national law was enacted in Queensland in 2014. And then basically that legislation was kind of sort of adopted across the other states. it has not been adopted across all states. And, you know, as with these things, there's, you know, discrepancies and all the rest of it. And I must admit, workplace health and safety went through the same pain with trying to harmonise workplace health and safety legislation back in 2011. That's been reasonably well done. In 2018 was when the chain of responsibility obligations were amended and the duties were amended, and how those duties are interpreted were amended and aligned with workplace health and safety principles. Now, interestingly, following that change, which has caused a real amount of angst, it has recently been decided that the entire legislation, Heavy Vehicle National Law, will be reviewed. So it's a little bit unfortunate that the review didn't happen before the rollout of the COR, because I think that might have helped, you know, not create unnecessary angst. But anyway, there we are. And the review of the HVNL is intended to further align the entire legislation with workplace health and safety. And one of the biggest differences between the HVNL and workplace health and safety law is HVNL is very prescriptive. Workplace health and safety law is generally not. It's what we call performance-based, which says you as an employer need to work out what your risks are and work out what the solutions are applicable to your circumstances, so you are controlling your risks so far as is reasonably practicable. But anyway, so we'll have a bit of a quick... So the HVNL applies to employers who are involved in the operation of heavy vehicles as an employer of their own staff, or who engage contractors who operate heavy vehicles. So Aldi, Coles, Woolworths, all the rest of it. Even if they only contract in transport operators, they are caught by the Heavy Vehicle National Law. A heavy vehicle is defined as greater than 4.5 gross vehicle mass, but a fatigue-related heavy vehicle is greater than 12 GVM. So if you're operating a heavy vehicle under 12 GVM, the fatigue elements of the Heavy Vehicle National Law do not apply to you and your operations. The law regulates 4 key areas: vehicle standards, making sure vehicles are safe and are safe to operate on the roads, maintained properly; mass and dimension of loads; driver fatigue; and then intelligent access systems. I'm not going to talk about intelligent access systems, but the 3 areas that are really relevant to most operators in this area or parties in this area are the vehicle standards, mass and dimension, and driver fatigue. If anyone's got any questions, please just pop them up, and I generally try and answer them as we go. So vehicle standards looks at maintenance and that vehicles are fit for purpose. Mass and dimension, loading within limits, load restraint, and limiting road access to oversized vehicles. Fatigue-related heavy vehicles, as I said, 12 GVM or over, sets down maximum work, minimum rest requirements, record keeping and work diaries. I have to say, I've been working with a client recently, and thank God I have had access to an expert in the field of the application, the operational application of the HVNL, because trying to navigate your way through the fatigue regulated elements of the legislation is a nightmare. It is very, very confusing, and it is very difficult to work out which bit applies, how it applies, how you're going to keep on track of it, all of that kind of stuff. So it is a difficult piece of legislation to work with, which means that small employers or employers who don't have necessarily access to, you know, expert advice are going to find it hard to implement and comply. The other area, I can hear these guys hammering next door now, which is just really, really terrible. But anyway, is the sound on? Adrian Pasqua can't hear the presentation. Sarah, you might want to deal with that. Mark Bernhard, interesting that the reference is made to employer and not PCBU. An employer is a PCBU. A PCBU is a person conducting a business or undertaking. The term PCBU is used in the harmonised jurisdictions. The term employer is used in Victoria. The term employer is used also within the transport industry, but a PCBU and an employer are the same thing. I'm going to say employer because I find it easier than PCBU, but if that's okay. Okay, so if we go on, I've got an interesting question here. So if a vehicle is under 12-ton GVM, fatigue laws do not apply. How is fatigue then managed? That actually goes right to the heart of this issue about the transport industry. Within the transport industry, employers have obligations to manage health and safety generally across the board, regardless of the heavy vehicle national law. So workplace health and safety legislation already applies to the transport industry. So even if you don't fall within the fatigue regulation under the HVNL, you still have to manage safety within your transport industry under the workplace health and safety legislation. So you've got to identify your risks, you've got to manage them, and you have to prevent, eliminate or reduce risks so far as is practicable. What it means though, if it's under 12 tonne, the elements within the HVNL which prescribe how you're meant to manage fatigue do not apply. But you've still got to manage the general risks, so you need to take a risk management approach, all of that kind of stuff. And this is where it gets confusing because you go, well, what does it mean? Which set of legislation applies? I mean, they both apply, but when do they? I'm going to talk a bit later about how I think we should go forward with this just to make sure that, just to make life a whole lot easier. All right, so if we go on, the other important part of the legislation is chain of responsibility. Now, this section of legislation has been interpreted in a very problematic way since it was introduced. The chain of responsibility is one section of the entire HVNL. It frustrates me when people talk to me about transport industry legislation as being the COR legislation. It is not the COR legislation. It is the National Heavy Vehicle legislation, of which the chain of responsibility is one section setting out the duties of other people or parties other than the driver. So people sort of go, oh, COR, and I notice people even have things like they'll have a COR manager who is responsible for all the transport compliance within the business. Well, it's not a COR manager. It's actually a manager of transport compliance or safety, because Chapter 1, Section 26C sets out duties, and it doesn't apply to drivers. It applies to anyone who can influence the safety of the operation of a heavy vehicle other than a driver. So it's targeted at everyone involved in heavy vehicle transport only to the extent that they have real control or influence. So I'm just going to jump ahead and bring up this little slide here. So if we think about it in really basic terms, there's consignors, parties that are sending out goods. There are the transport operators, they're operating the trucks, employing the drivers, and then there's the consignee, which is the person or the party receiving the goods. It's a really simple way of dividing this up. And what chain of responsibility does is it means if you're sending out goods using a transport operator who is and a driver to send out goods, you have obligations to make sure that what you do does not cause that driver to drive, engage in unsafe practices in relation to the heavy vehicle. And the same if you're receiving the goods as well. So I'll just jump back a little bit here. So the purpose of this section is to make sure drivers of heavy vehicles are not encouraged, coerced, or influenced to engage in unsafe practices which pose a risk to them or the public. The important point here is that it relates to matters over which the party has control. This is not fanciful control. This is not saying, oh, look, I just happen to be in the chain somehow because I'm sending out some goods, but I've got actually no control. I have no direction or no influence over how that truck is operated. It is targeted at where a party has actual and real control or influence over how the truck is being operated. And we'll talk about that in a second. It's proactive. So if you're a party in the chain, you need to think about, right, so I'm a consignor of goods, I'm sending some goods out, I need to think about, well, what are the ways that I might influence that heavy vehicle to be operated unsafely? So I might be actually telling the driver that I need to get this package from Melbourne to Sydney in 8 hours. We know that can't be done safely, and that would force the driver to speed or fail to take breaks, to manage their fatigue. So it's about what you actually have control over. I have heard people say, oh, yes, if a truck leaves your yard as a consignor and they have a rollover down the road and it's because, the maintenance of the vehicle wasn't done, even if you had nothing to do with the maintenance of the vehicle, you will be held somehow responsible. Well, that's rubbish. You need to think about what are the things that you have actual control over. So who are the duties targeted at? As I said, distributors of goods, so consignors, transport operators, not the driver, but the transport operator. So the company that owns the truck, employs the driver, schedules the work, all of that kind of stuff, and the consignor. So the receivers of goods, they also, so for example, Coles is receiving goods. They force the driver, I'm not picking on Coles, but I'm giving you an example. They force the driver to be waiting for 3 hours before they can get unloaded. That is going to force the driver to go over in the terms of their fatigue-related hours. That is a decision that if the driver then drove off down the road, had an accident, and it was found to be contributed to by his level of fatigue, Coles would have a problem because they have had actual control or influence over how that driver's safety and the safe operation of that vehicle. Let me just, here we go. Okay, so we've got some questions about WA. So road traffic or the heavy. So the actual legislation, so my understanding is that WA is in the process of looking at handing over HVNL to the National Heavy Vehicle Regulator. So if you look at Gary DeVries, if you look at the National Heavy Vehicle legislation, go into AUSTLI, austli.edu.au, and look under National Heavy Vehicle, the Heavy Vehicle National Law, the legislation should come up. So the duties are targeted at those parties. So if we keep going there, I'm just trying to watch these questions as well. Sarah O'Leary would like to answer. No, that's okay. What if the driver did not strap down his load correctly? Well, I think that's fairly straightforward. If the driver is responsible for strapping the load and restraining it properly and failed to do so, then yes, that's his problem. Because, and this is a good example of where people think COR is the kind of important part of the Heavy Vehicle National Law. The other elements, as we looked at before, let me go up here, jump back a little bit. The other elements of the legislation around vehicle standards, mass and dimension, and driver fatigue. So mass and dimension talks about how you need to load and restrain the vehicle. That applies to anyone involved in the load and restraint, the restraint and loading of a vehicle. So if the driver's responsible for loading and restraining, that's his problem. So think about it in terms of who's got control over each activity. Okay, let's go back here. So in terms of those duties around chain of responsibility, the Heavy Vehicle National Law is now aligned with workplace health and safety. So under workplace health and safety duties, an employer or PCBU should identify all circumstances in which their employees could be at risk while at work and all the circumstances in which anyone else could be at risk as a result of anything done in his business. So under workplace health and safety, which applies to the transport industry, you as an employer or as a party in the chain of responsibility need to think about how do I create risk for my own employees and how do I create risk for others? And the alignment with the HVNL, each party in the chain of responsibility i.e. involved in a transport activity, must ensure, so far as is reasonably practicable, the safety of the parties' transport activities relating to the vehicle. And what that is saying is think about how you can impact on the safety of others, in this instance, the driver, in coercing, influencing or causing them to be unsafe. So what we talk about this shared obligation, and I must admit it's a term that has created a fair bit of angst, because people go, oh, shared, therefore everything and anything that happens in the chain is shared. And that example I gave where, you know, the transport operator has failed to maintain his vehicle, you use a transport operator, you contract them in, the truck rolls over or has an accident because of that failure to maintain, and somehow you're held responsible. That is not the case. The shared obligation is to make sure you don't do anything which forces another party in the chain to engage in unsafe practices. It is not about interfering in another party's operations which you are not involved in. COR is about obligations owed to drivers who are impacted by your operations. So again, long wait times. You know, if you're sending out a load which hasn't been labelled properly or contains dangerous goods that you haven't advised are in the load, is not loaded properly or restrained properly, if that's your responsibility, all that kind of stuff. The changes do give teeth to the National Heavy Vehicle Regulator to prosecute parties who contribute to heavy vehicle incidents, who are not directly involved in the operation of the vehicle. So like, for example, Sports Girl engages a transport operator. If they are involved in the operation of that vehicle and are conducting their business in a way that causes that vehicle to be operated unsafely, then they have a risk. Okay. I just got Larry, I can't follow what you've got there. Anyway, so if I go back to the slides here, excuse me. So the changes do give teeth to the NHVR to prosecute. So it means the whole point of doing this, so that the prosecution used to really focus on the driver and what the driver had done in terms of managing the safety of the vehicle. This now extends that obligation to outside the driver. As I said, we can look at it in three ways: consignor, transport, consignee. So what heavy vehicle risks outside of your own operational risks, so I'm Coles, do I have control or influence over? So if we look at the consignor, a consignor engages a transport operator. They consign goods for transport. They may pack and load them, or they may not. They may say, no, we want the transport operator. Well, they'll probably pack them. They may not load them. Scheduled delivery. They may or may not schedule delivery. Heavy vehicle safety includes wharf transfer and freight forwarding. So consignors is a group who are sending out goods. Heavy vehicle safety matters over which you have control or influence. These are some examples of the sort of things that consignors have control or influence over. Overloading. If you are consigning a load and not putting the correct weight on it, then obviously you can have an influence over the overloading of the vehicle. You may put pressure on a driver to overload, and that can be overtly by telling them to overload, or it can be, not as overt by just putting pressure on them through, things like business practices, all that sort of stuff to overload. Things like loading dangerous goods, scheduling which may force speeding or fatigue, and wait times which can increase fatigue. So again, it's looking at what have you got control over and how can you influence whether that driver is going to engage in unsafe practices. Let me just jump to these questions here. I just want to have a look. So this is asking things like, so Vanessa asked, hi, if our drivers do not load and restrain but rather it's loaded by another employer, who's responsible? Well, who did the loading? So if the driver has been provided with information that states that a load is of a particular load, there are things around weigh bridges and getting loads weighed and transport operators need to do those kind of things. But at the end of the day, if a driver turns up, a load is provided to them, it's loaded on the vehicle, they've confirmed by, that a load weighs a particular weight, then it is a loader who would have the difficulty. Is there a guide on what is considered reasonable waiting time for heavy vehicles? I'm not aware of that, but that's okay. I'm sure there probably is. But again, you see, this is the interesting thing, because if we look at performance-based, you'd say, well, a reasonable wait time can vary. It can vary based on the facilities provided for a driver to wait in. And it's about taking a problem solving approach, and that's where this push towards moving the heavy vehicle national law is going towards, rather than providing prescription, but saying you need to think about what are the risk control solutions in your circumstances. What happens if the driver doesn't know their capacity? As a consignor, would we refuse to load them? Well, I would have thought it'd be fairly obvious what the capacity is, because the vehicle has a GVM. But anyway, yeah, if you can't determine the capacity of a vehicle, then how are you going to be able to know whether it's loaded safely or not? If you allow a load to leave your yard knowing that it is not correct, is the driver still responsible, or does this now come back to the consignor? If you load a load and you have knowledge that it is overloaded, then you would be advised not to let it leave your yard, because you've got a part to play in the loading of that vehicle. Okay, there's quite a few questions coming in here, but I'm just going to go back. Roy Gillespie, as an end user, prime contractor, what accountability do we have to ensure compliance? It's an excellent question. We're about to get onto it. What expectation is on us to verify that everything you are presenting is happening? How far down the line are we expected to audit and verify? Excellent question, because I'll just finish looking at this. So transport operators obviously have influence over loads, they load, transport and deliver goods. They have influence over vehicle safety, driver fitness and driver competence, so they need to look at those issues. They need a consignee. They unload goods, basically. Heavy vehicle safety matters over which they have control are generally things around wait times, could be things like scheduling. We need to be receiving the goods by a certain time or within a certain time slot, and that can then influence, fatigue and so forth. But this is just to show, it's not a definitive list, but it's to show you how you need to look at your own operations and say, what is it that I'm doing that could impact on this driver to make them engage in unsafe operation of a heavy vehicle? This question about how far do we need to go when we're engaging transport operators or contractors to provide transport services is really goes to the crux of the change under COR. The change under the chain of responsibility brought it into alignment with case law, which has been handed down since 1986 and was really crystallised in the workplace health and safety space in 2012. That case law determined that a principal contractor or prime contractor, which is the term we use in the transport industry, is entitled to rely on the expertise of the independent contractor they are engaging to manage the risks associated with the work the independent contractor is doing. So if we look, there is a limitation to the obligations around what a prime contractor needs to be doing to manage their contractors. So the obligation to eliminate or reduce risk so far as is reasonably practicable is qualified by the capacity to influence and control the conduct of others, i.e. the contractor. Note, this is real control and influence. It's not some fanciful down the road thing. The capacity to influence and control another party is limited by the cost and effort of controlling and directing independent contractors in their safety arrangements. So the court looked at this issue and discussed the fact that you're engaging an independent contractor who is an expert in the field that they or the area that they're providing you services in, or is supposed to be an expert in their field. It would be wholly inappropriate for a prime contractor or a principal contractor to start directing that contractor in how to do their work. And there was a quote in one of the cases where the High Court judge said, if I had a plumber and electrician in my house doing work and I started to direct them in how they should be running their safety or running their business, they would quite rightly get quite frustrated with me and ask me what was I on about. And it is the same in the transport industry. So the principles set down by the High Court in 2012 have been adopted by heavy vehicle national law in respect of the duties owed by prime contractors to contractors and for contractor management of safety. They have been limited by the concept of reasonable practicability. It is not reasonably practicable for you as a prime contractor to be constantly across what your contractor is doing in terms of maintenance, driver fatigue, management of their vehicles, and all of the matters that they are under control. So what we need to do is show a level of due diligence. The court said you can't possibly be running around checking everything your contractor is doing. And that includes things like, I want to see copies of all your licenses. I want to see copies of all your maintenance records. I want to see copies of all the training you do. I want to see, it's just not practicable. And it's not even valuable. I've been working in this space for a really long time. And quite frankly, the administrative processes that people go through to collect copious amounts of information from their contractors is nigh on pointless. One, it's backward looking. It only tells you what the contractor's done in the past. That may not reflect what they're doing now. It's so often the experience that preparation of documentation to supply to a prime contractor by a contractor is done for the purpose of winning a contract. What is actually happening on the ground within the contractor's business is often has nothing to do with the supposed documentation and evidence that they've provided you of the systems that they're actually implementing on the ground. So what do we need to do? How do we need to manage this? What we need to do is manage contractors with just shutting that down, with good reputation. We know who transport operators are with good reputation and drivers who have good reputation. Ask the right questions. So what we can do is ask them, do you have safety arrangements in place, or do you have arrangements in place to meet your obligations under the heavy vehicle national law, not the COR elements of heavy vehicle national law, but the heavy vehicle national law, which means, do you maintain your vehicles, do you manage mass and dimension, and do you ensure driver fitness for work and manage fatigue? You are entitled to rely on a yes, no answer. So if you say to a contractor, do you have arrangements in place to manage fatigue, and that driver says yes, then you're entitled to rely on that representation. You do not need to then run around collecting copies of workbooks, road diaries, all that kind of stuff. That is the obligation of the contractor. Don't collect copious paperwork. As I said, it's pointless. It doesn't mean anything. It's not evidence of what is actually happening on the ground. And quite frankly, I think it's a distraction from the contractor spending their time actually managing safety on a day-to-day basis and within their business. They run around preparing complex documented systems, which generally don't reflect what's actually happening. Clearly establish the scope of work and the responsibilities of each party for safety and compliance with the heavy vehicle national law. So if you are a consignor, you are sending goods out, you can say or define the fact that you will be packing and loading your freight onto the vehicle and confirming that it is loaded within mass, it is loaded within dimension, it is properly restrained, it complies with the description of what the load actually is. If that's the case, make sure that is well understood that that is what you are doing. If that is not what you are doing and you are saying to the transport operator, we would like you to supply a vehicle and come to our premises and load, restrain, and confirm that the load is actually loaded in compliance with the Heavy Vehicle National Law, then make sure that is clear. Separate the obligations and be really clear around who is responsible for what. Understand what obligations you do retain as a prime, my apologies for the term principal, as a prime contractor. You are responsible for what happens on your own site. So when a driver comes to your site, you are responsible for what happens on that site. You are responsible for managing safety risks from your operations. So you need to be considering, well, what are you loading? What are you sending? Is it safe to send those items? All of those kind of things. So think about your own operations and consider how your operations may pose a risk to drivers. So think about, how are you using transport operators? Again, load, mass, dimension, driver fatigue. What is it that we're doing that can influence a driver to be unsafe? Direct contractors to remedy your safety concerns without directing them on how this is to be done. So if a driver arrives on site and has a vehicle that is quite clearly not maintained, it is important to go back to the contractor and say, look, we're not happy with the standard of your vehicles. You need to put systems in place to manage that, and we expect to see vehicles that are in a better state. It does not mean you have to be actually physically inspecting the vehicles. But if you do observe that there are issues, you do need to, from a safety prevention perspective, be raising that with the transport operator. Just going to have a quick look at these questions again. Anonymous says, are we responsible under, no, how does COR apply to international freight being imported into Australia? It totally, well, please, again, it's not how does COR apply, it's how, well, it sort of is, it's how does the National Heavy Vehicle legislation apply? And freight that is being imported, there are issues around its packing overseas, its weight when it arrives. It's not practicable to unload and open up every container and all the rest of it. So again, reasonable practicability does apply. Are we responsible under COR if we give a company directive to deliver a piece of plant by a certain date time? You may well be, if that certain date and time means that the distance covered is too great or within that time and the driver needs to speed or they need to, can't have their brakes. So you may well. So you need to think about your scheduling and so forth. What about responsibility to audit your process? Now that's Paul. Now, obviously, every employer has a responsibility to manage and review and monitor their own safety processes. So if you're the consignor, you need to make sure that your safety processes in relation to what you do and the risks you create are being audited, monitored, make sure that your processes are being implemented. Equally so, transport operators have obligations to audit and manage, make sure their processes are being implemented. But what you don't have to do is audit somebody else's, okay? Okay, what if anything would be advisable to audit in regard to transport contractors? Well, I'm going to go out on a limb here and say pretty much nothing, because you are responsible for what you have control over. You need to be making sure that what your operations, think about your own operations and say, what is it that we are doing? How can we create a risk? And what is it we need to be doing to stop that risk or to manage, eliminate that risk? The problem I find is we've got too much focus on what everybody else is doing, and it's distracting us or the parties from saying, well, what am I doing? Whereas if we each looked after our own backyard, we wouldn't need to look over everybody else's fence. Okay, so we'll go back to our slides here. So the next one is, what should I ask? Well, this goes to that question about what should we audit? I mean, we shouldn't be auditing other businesses' operations. It's not your obligation, and it's unproductive, and it's not, it's not going to take us where we need to do. When you are asking questions around your transport operators or asking, parties what they're doing to manage safety, we're interested in the what, not the how. I often look at questionnaires, pre-qualification questionnaires, and a classic example is, do you have a training program? Are your employees trained? Is your training program regularly updated? Do you use qualified trainers? The only answer we really want is, are your employees competent to undertake the work they are undertaking? So make sure the questions you're asking are really targeted to what you actually want to know. So things like, are your drivers licensed? Are your drivers competent in load restraint and mass management? Are your drivers fit for work? Are your vehicles safe and fit for purpose? So just hit the nail right on the head. Not, do you have a maintenance program? How often do you maintain your vehicles? Blah, blah, blah. It's, are your vehicles safe and fit for purpose? Yes. Now that means that you have achieved that by having, arguably, an appropriate maintenance program, blah, blah, blah. So for things, for others in the chain, are your work processes designed to support drivers to observe speed limits, comply with road rules, maintain fitness to work, load within vehicle limits, correctly restrain loads? So I've had a lot to do with drafting and reviewing question sets over the years, and I really do see a lot of variation and a lot of problems with unnecessary questions being asked that really don't get to the heart of the matter. Okay. So get your own backyard in order. Have a good hard look at your operations. Remove operations or practices which result in drivers engaging in unsafe acts. And they may be deliberate actions or systemic. We may be deliberately instructing drivers to actually overload, or they may be systemic, which is we're scheduling in a way that forces a driver to drive even though we're not consciously doing that. Or we're just not thinking about, what the impact of that is. Trainers' responsibility duties does not extend liability for operations of others in the chain, e.g. a freight forwarder is not responsible for vehicle maintenance or licensing of a contracted transport operator. Okay, so that message here is, look at what you're doing. So let me just have a look here. I'm just going to have a look at just check the questions again. Are you able to elaborate on the defensibility of reliance on yes/no questions of contractors to discharge the obligations of due diligence? Well, I'm going to refer you to the High Court case, Bayada versus the Queen, 2012, where the High Court specifically said a principal contractor, aka a prime contractor, don't worry that case is not in the transport industry. The principles are exactly the same. The Heavy Vehicle National Regulator, the NHVR, has confirmed that the principles out of that contract inform the application of COR duties. So I would refer you to that case, and that is the High Court specifically quoted that in regard to due diligence, and saying that you are entitled to rely upon the expertise of your contractors to manage their health and safety risks. As we have influence and control over who we use for transport, shouldn't we then review a transport company's operation because we use our influence and control to choose? Yeah. This goes to the thing about contractual control. So, yeah, okay, we may have contractual control, but the obligation to manage risk under the Heavy Vehicle National Law and workplace health and safety is so far as is reasonably practicable. And the High Court looked at the question of, is it reasonably practicable to direct the contractor in how they go about doing their work, or to go to the kinds of extent around receiving, reviewing, checking, monitoring and supervising the way that a contractor undertakes their work. And they said, no, it is not reasonably practicable. The cost and effort involved is just phenomenal. And you may not have the knowledge. Who says that you've got the knowledge to actually review those processes and practices? I find it interesting that we always think about this through the eyes of big employers. Now, sure, Aldi probably have people on staff who can look at a transport operator's processes and go, yep, okay, that fatigue management process is compliant, or that vehicle maintenance process is compliant. Well, the ABC, grocery store on the corner doesn't. And so there is no obligation to review, monitor and supervise the implementation of the safety arrangements of a contractor. Let me just scroll down here. So small companies do not have to worry about COR, only Aldi does. No, absolutely not. Everybody does. What I'm saying is, as I've said, chain of responsibility is about you as the party engaging the services of a transport operator or driver, making sure that you do not do anything to force that driver to engage in unsafe acts. Can you please advise the actual HVNL section specifically for COR? So the HVNL section is section 26C. So if you go to the Heavy Vehicle National Legislation, you'll see that under section 26C, and it sets it out in there. Okay, so if we go back to our slide presentation, sorry, just current slide. Oops, sorry, I got jumped ahead. So they've gone back to dropping material next door, and it's creating a bit of noise. But as a result of the review, which is necessary, of the National Heavy Vehicle Law, because the current law does not reflect best practice, it is onerous for industry. It is incredibly difficult for the regulator to administer. It's not truly national. It's overly prescriptive, and it's complicated to navigate. So the HVNL is to be reviewed. That quote was from the NTC, the National Transport Commission, to align it with, more broadly, workplace health and safety principles, performance versus prescription. So what we're going to be looking at is saying employers or PCBUs in the transport industry need to understand their risk and develop risk controls or control methods, elimination and control, that controls the risk so far as is reasonably practicable. And to be honest, I've thought about this for a while, and having worked with the legislation, having worked with employers in the transport industry, both employers who operate transport, do transport operations, employers who engage transport operators, it's really quite a difficult space to work in. And I'm not sure why the model adopted under workplace health and safety legislation is not adopted. Basically, Safe Work Australia can develop harmonised heavy vehicle regulation, perhaps based on the existing HVNL, who knows. Transfer the regulation of the transport industry to state workplace health and safety regulators. I do think perhaps under a transport division. I think there is a problem that the transport industry somehow kind of sees itself as different to every other employer in the country. And I think it would be really helpful to say, no, you're an employer like everybody else, and workplace health and safety legislation applies to you, and there's a set of regulations that is specific to transport. And also clarify enforcement. Put enforcement of health and safety related matters under the workplace health and safety regulators within each state, perhaps within a heavy vehicle division. VIC roads look after the roads, proper use and compliance, and the police can look after criminal conduct on the road, drink driving, speeding, not workplace related incidents, because it seems to me that you can have police, VIC roads, WorkSafe and the NHR all working at a roadside block, pulling over vehicles, dealing with them and doing various bits of enforcement, and it is just so confusing, it isn't funny. So there's a little option for you. to maybe try and straighten out some of this confusion. But anyway, look, I think we're at time. Oh no, it's 10:02. So I'm just thinking, has anybody? Let me just pick these other questions. How does heavy vehicle national law apply to mobile plant greater than excavator that is registered and operated on a suburban street? So in fact, it does apply. So if you look at the legislation, it applies to truck-mounted equipment. So where you've got, say, an elevated work platform mounted on the back of the truck, and you're operating the elevated work platform, that all counts as operation of a fatigue-related heavy vehicle. There are some interpretations around the vehicle must be a vehicle which is designed to transport goods and people or people. So this thing around mobile plant, if it's something like a piece of farm machinery or a piece of machinery that is doesn't have that interpretation, then there can be some variation. But this is where it gets so confusing. Like, what's in, what's out, when does it apply? It's all a bit of a nightmare, to be honest. Gavin Wright, North Queensland. Why then do the Main Roads Department and the Federal Safety Commissioner stipulate as one of its primary requirements that we require all contractors' compliance documentation and records prior to their procurement and issuing of a contractor? Well, I'm going to say to you, because the Main Roads Department is not up with the interpretation, the latest interpretation of the legal duties of prime contractors in relation to independent contractors. Federal Safety Commissioner has actually changed their view in relation to requirements around collecting and inspecting contractor safety documentation. There is a difference between guidance and the actual legal interpretation of duties under the law. Now, the reality is what you're going to be prosecuted under is the actual duties as they are interpreted under the law. The interpretation of the legislation, as I said, the decision was handed down in 2012. I'm still finding here, even across the workplace health and safety regulators, some of them don't have their head across it. But, this is an area I have worked in for a very, very long time and have been extremely vocal about the very poor understanding of the obligations placed on prime contractors and principal contractors to, inverted commas, manage contractor safety. And when I say manage, I mean interfere in, take over, monitor, supervise, and approve contractor safety arrangements. It is unproductive, it is unhelpful, and it is a distraction from each party attending to what it is they actually have control over. So I've got another one here. As a consignor, do you have a simple chart showing different parties in COR and the typical risks they need to be concerned about? Yeah, well, that was in the slideshow. So this slideshow will be available. I mean, basically, I just gave a bit of a summary of the sorts of things that you need to be looking at. So have a look at the slideshow. I have heard talk about this legislation applying to utes, especially with regard to load restraint. Is this the case? Is there different legislation, or is it an urban myth? I have actually heard a little whisper of that myself, and I think it's an urban myth with regard, because obviously a ute is definitely not a heavy vehicle. But as you say, apart from routine risk management and best practice, if you're operating a ute as part of a workplace and part of workplace operations, you must comply with the workplace health and safety legislation. So if you have a ute out there with an unrestrained load and it comes off, and you're an employer, you're a plumber, got all your gear in the back, and it all comes off and hits somebody else on the road, you're liable for prosecution under the workplace health and safety legislation. Okay, can I please reference the 2012 common law case? So well, it's not a common law case, but it was a well, yes, sorry, it is a common law case. I had a workers' comp brain fade there. So the common law case is BAIADA, BAIADA, Poultry versus the Queen, 2012. It's actually a very interesting case to read. It's very easy to read, and the judgment is actually really quite clear. So it's not that I just don't have a life and I spend my time reading this stuff. It is something. It is worth reading. Just to clarify, who is the authority that should be providing guidance in this area? It absolutely should be at this time the National Heavy Vehicle Regulator. So look on their website and see what sort of guidance they've got. Unfortunately, some of it's a little bit confusing, but that's okay. Here we go. Recently, we requested information from New South Wales Maritime and Transport Services as we had delivery from WA going to New South Wales. The vehicle is under 12-tonne GVM, so in regards to fatigue management, the vehicle doesn't fall within this category, yet main roads ask for fatigue sheets, fatigue management certificate. Are they entitled to do that? We don't have this paperwork. Where do we stand under Workplace Health and Safety NHVL? So the NHVL doesn't apply in terms of fatigue under 12-tonne GVM. Workplace Health and Safety always applies to every operation that any employer, including the transport industry, undertakes. So I hope that's helped. All right. Oh, and just here, there is a specific load restraint guide for both heavy vehicles and less than 4.5 tonne across Australia. That's great. Look, there is a lot of material available in terms of providing guidance around the operational elements of how to manage mass, how to manage dimension, how to manage fatigue. This session was really interpreted to try and drive home this point that chain of responsibility is one element of the heavy vehicle national law. It is the element that sets out the duties of parties to not do anything to force a driver to engage in unsafe behaviour. It does not mean that you need to be running around going over to your contractor's workplace and checking out what they are doing to manage their risks. You need to demonstrate a level of due diligence when engaging your contractors, and that can be achieved by making reasonable inquiry into the operations that they are undertaking. It does not mean that you have to have complex contract management systems where you're collecting, reviewing, amending. God forbid you should amend your contractor's safety documentation, because then you're really taking control. So, you know, it's about look at your own backyard and manage what it is that you have control over. I think we're out of time. Sarah, are you there?
I'm here.
Would you like to?
I would like to thank you very much, because that was excellent. Very much appreciated by, I'm sure, everyone attending.
Sure.
There are a few questions remaining. We'll try to get to them possibly afterwards. And I just want to let everyone know that, yes, we will be emailing within 24 hours the slides, a link to the slides, a survey for the webinar. If you could possibly let us know how you feel, and also what other sort of topics you might want to hear about. And a video recording as well. And if anybody is interested in myosh, then obviously go to the website, fill out a free trial form, and the consultant will come and have a chat with you. Yeah, so basically, if you can do the survey, that would be great. Is there anything else you want to say, Sue?
I just want to if the participants can have my contact details. So if you've got questions, please get in touch with me. Email Sarah. Is there a way of including that with the? I
wanted to ask you that. Yes.
Yeah, I'll add it as a slide. So when the presentation goes out to participants, it'll be on there.
Yes, and also in the email I send as well.
Yeah. Okay. No worries. So then, yeah, that'll provide people with me with sorry, I'm rambling now. With being able to get in touch with me and ask me specific questions and so forth. But look, it's not an area that should be hugely complicated. It's been made very complicated. So please get in touch, and, you know, happy to help out any further if people want to ask more, you know, for greater assistance. That'd be fine.
Great. All right. Okay. Well, that was a very productive hour. Thank you so much, Sue, and thank you to everyone who's attended.
Okay. Thank you.
Thank you.
Bye.
Bye-bye.
Bye.